Mr. Pretorius.
By your leave, Mr. Chair, Advocate Maleka will deal with the next session of proceedings.
Thank you. Mr. Maleka.
Thank you very much, Chairperson. As we have indicated to you in chambers, there are several of our colleagues who appear for a number of individuals who have been implicated or may well be implicated by witnesses who are going to testify before you in the next several days. All of those persons have been given notices in accordance with the requirements of Rule 3 of the rules regulating the proceedings of the Commission. And they have indicated that they'd like to make some submissions to you in order to make directions regarding their right, if any, to cross-examine witnesses who may be testifying before you, and also any choice or election they may make in regards to filing their own opposing sworn statements and or their right to testify in person with or without additional witnesses. Subject to your direction, I would like to invite you, Chair, to invite those of our colleagues to place their names on record and indicate who they represent, and also indicate to you what sort of directions they would like you to make. I know that one of them, Mr. Chair, is Mr. Mike Helens, and perhaps he should start, not only because of his color or seniority, but the enthusiasm with which he indicated that he'd like to lead this part of the discussion on behalf of the implicated individuals.
Thank you. I've had discussion with the legal representatives of various parties in my temporary chambers here. May I invite you, maybe in the order in which you spoke in chambers, to come forward and place yourselves on record and indicate what you would like to say, and maybe Mr. Pretorius might wish to remove the file there. Thank you.
Is this on or not? Yeah. Thank you, Mr. Chairman. My name is Michael Helens, Senior Counsel of Johannesburg. I appear together with Mr. David Jubé, SC, instructed by Rudy Krauser of BDK Attorneys on behalf of Mr. A.J. Gupta. But I do so in relation to the Rule 3.3 notices served on the 6th of August in respect of the evidence of Ms. Mcebisi Mentor and Mr. Themba Maseko. They were left at the gate of the Saxonwold residence of Mr. A.J. Gupta. I do not appear in respect of the evidence or implications of the evidence of Mr. Mcebisi Jonas. I also represent with the same team Mr. A.J. Gupta in respect of any other allegations that may be made, and we've heard a wide-ranging and very able introduction by Mr. Pretorius on the length and breadth of that which is going to be dealt with in this commission. It would appear to us that we may be due a number of other 3.3 notices, but at the moment we just have those two. And as indicated in chambers, we would invite the evidence leaders to engage with us and to give us such notices as soon as possible. To sketch the background or the introduction to our appearance here is that naturally, as with the rest of the nation, we've known that the Commission would start, but when and how and what the mechanics would be were not known to us until at least the 3.3 notices were served, the Rule 3.3 notices were served, and in part also the able address of Mr. Pretorius. So now the planning from our side can ably begin. But the rules, as you're aware and the public should know, require us firstly to be given reasonable notice. And we know, sir, that the Commission had to start somewhere, somehow, and you've done a lot of work in being ready to prepare. So we make no complaint of what is technically short notice. We simply propose to put in place if you'll give us leave to negotiate with the evidence leaders, a reasonable time frame in which to deal with the evidence. At the moment, I'm speaking in relation to the evidence of Mcebisi Mentor and Mr. Maseko, but I speak also broadly to my learned friends on my right and left in relation to such future pieces of evidence that may call for cross-examination or evidence from our clients. So the notices state that the witnesses will give evidence at the hearing commencing on 20 August, but we know that this is the commencement and not necessarily the date on which all these witnesses will give evidence. It appears to us that whatever the plans are of the Commission need not be interfered with by our temporary and justified lack of readiness, because the witnesses, in our respectful view, can still give evidence in terms of the planning of the Commission, because transcriptions will be available and no doubt even video facilities might still be available. So we would not interfere with the program of the Commission in relation to when the evidence is led, but we would ask that we make practical arrangements, not aimed at delay, merely to get ready in terms of the rules, to present cross-examination and to present such affidavits or evidence as we are required by the rules to file in order for you to exercise your decision-making powers in relation to the range of cross-examination, the nature of evidence, and the differences between what the Commission is leading and what we might want to put forward. But for that, we do need a little time. We've discussed that broadly already in chambers, and I'm sure my learned friends and I and my team will reach accommodation with each other. Just a slight correction without starting the war. We have not been given due notice, as Mr. Maleka said, under the rule. It's actually quite short notice, but we make no complaint about that. And in a nutshell, we would ask for time to make appropriate arrangements for us to represent the stage, Mr. A.J. Gupta, in relation to the two raised issues. But at the same time, we indicate publicly and to my learned friends, if there are other issues, please give us time as notice so that we do not delay the proceedings of this inquiry. Our suggestion, just to think about, is given the demands on our time in relation to our own practices and prioritizing being ready, we believe we would be ready to cross-examine by the first week of September at the latest, but the actual detail we'll deal with the evidence leaders, subject to your decision, sir. Thank you.
Thank you very much, Mr. Helens. Thank you.
Thank you, Mr. Chairman. My name is Dawie Uber. I'm a member of the Johannesburg Bar. I confirm that I appeared together with Mr. Helens as he set out, and we obviously echo his sentiments.
Would you please just raise your voice a little bit? It's rather soft.
I also am instructed by Peter van der Merwe, attorney, to appear on behalf of Mr. A.J. Gupta in relation to the evidence which Mr. Jonas might give. We are awaiting instructions on behalf of Mr. Duduzane Zuma and Mr. Rajesh Gupta with regard also in relation to the evidence of Mr. Jonas. Hopefully by early next week we will get clarity on that. Similarly, the Section 3, or rather the Rule 3.3 notices were only served in respect of Mr. A.J. Gupta and Mr. Rajesh on the 13th of August, incomplete, and that of in respect of Mr. Duduzane Zuma was only served on the 14th according to the instructions. Thank you, Mr. Chairman.
Thank you. In terms of what should happen, do you align yourself with the attitude taken by Mr. Helens in terms of what should happen going
Yeah.
forward from now on?
Indeed so.
Thank you.
Thank you.
Thank you, Mr. Chair. I'm Jaap Celia. I'm a senior counsel of the Pretoria Bar. I'm instructed by Mr. Stockenstroom Fouchier to act on behalf of Mr. Fana Shlongwane in this matter. We have received the 3 notices, but only on the 10th of August, and also in our instance, the statement provided as an annexure to the notice of Mr. Jonas was completely incomplete, in the sense that I gathered from the statement that at least 6-7 pages were missing and not sent through to us. But also, we don't want to complain. We also align ourselves with the sentiments expressed by Mr. Helens in this regard. If we can have the opportunity to discuss the matter with the legal team and arrange times in order to be provided the opportunity then to prepare for cross-examination of Mr. Jonas. Because at this stage I can indicate to you, Mr. Chair, that my instructions are that Mr. Shlongwane indeed want to participate in these proceedings, at least at this stage to cross-examine Mr. Jonas, and thereafter to take a decision as to whether he deems it necessary to testify and or call witnesses, as you indicated he may be entitled to. So, but for purposes of the procedures to be followed, we align ourselves with the views expressed by Mr. Helens, as you please.
Thank you, Mr. Celia.
Thank you, Mr. Chairperson. My name is Muzi Skakane. I'm a senior counsel from the Johannesburg Bar, Victoria Mkanya Group. I'm with Mr. Masugu SC and Mr. Mpilo Skakane. We all representing Mr. President Jacob Gedlehlekisa Zuma. Chairperson, we rise. Our position is slightly different, as we discussed in your temporary chambers, in that while we seek an opportunity to respond to the Commission in terms of 3.4, the application we wish to make today is in terms of 3.5, which of course requires that we be given sufficient opportunity. And that, I'm starting at the end, that is the opportunity we seek, and it's in terms of that rule that we make this application. But having said that, because I started at the end, we wish to make the following point, is that we have received 3 notices, and I appear on behalf of Mr. Zuma in relation to that notice, which is the notice which relates to Mr. Maseko. The second one relates to Ms. Mentor. The last one, which we got at 25 to 10 on Friday in the evening, relates to Ms. Williams. I mentioned the time because we want to make it clear that we do not want to delay this process, and to the extent that our learned friends have suggested a way forward, depending on the election we make, we have no intention of stalling that process. It doesn't matter what we elect to do. But the point I wanted to put on record, Chairperson, is that we received the notices on the 3rd of August. And those are notices in relation to Ms. Mentor and Mr. Maseko. And as I said, we've received the other one on Friday. But the issue really that has made this difficult for us is that we have raised questions, and those questions are not just further particulars, it's to to obtain certain documents because we want to make a meaningful participation in this process, this very important process. And so what we've asked are documents that we believe will make it easy for us to know what case we have to meet if we make the election, that the implications that the Commission makes on the statements are the elements about which we think we should, or the client thinks he should come here. And therefore, what we request, Chairperson, is that we be given time starting from today, because as I said, we got a 103-page document only on Friday when we requested further documents. And therefore, we want to place it on record that we will make no delays, we will cause no delays, but we want to be given time to make that election, whether to exercise Rule 3.4, which says we must make a statement. But we, unlike my other learned friends, we've not made that election because we require to know exactly what case to make. I do not have to repeat the documents that we've asked for. They are self-evident because this process is truly about getting the evidence, and it's not a process about any flimsy discussion at a coffee shop with a friend. It requires evidence, and we want to place on record a proper case.
Thank you very much, Mr. Skakane.
Thank you, Chair. My name is Welcome Lusenga. I come from the Pretoria Bar. I will be led by Similibala SC in this matter. I approach on a different footing in that I act for the former Minister of Public Enterprises, subject to confirmation of instruction, her Director General, and possibly the Chief Director. Unlike other speakers who have risen, our client...
You mean the immediate former Minister of Enterprises?
Ms. Lynn Brown.
Ms. Brown.
Indeed.
Thank you.
Unlike other persons who have risen before you, our client did not receive any notice, nor are we soliciting for any notice. Given the nature of the terms of reference, given the institutions that are being covered, which were in her portfolio, given the developments in other commissions outside of this one, it is likely that she may be implicated by the evidence that would be led by different witnesses on different aspects. To be able to exercise her rights fully, to make the elections that she needs to make, and if possible, refute any evidence that has been placed implicating her, we request that we, hopefully from today, be included in all correspondence relating to notices that have been issued or that are going to be issued, the summaries of the witness statements that are given to all other participants in this matter. As far as the participation is concerned, we, like the other legal teams, stand on that footing. We do not want to delay this matter. We will align ourselves in terms of the arrangement that let the evidence be led. Our cross-examination, if any, will be deferred to an appropriate time so that the commission time does not get wasted.
Thank you very much.
Thank you, Chair.
Thank you. I don't suspect that Mr. Malega, or there is still one more counsel.
Thank you, Mr. Chairman. Henry Cowley, counsel from Johannesburg. I'm instructed by McMinimum van Eysteen and Botes on behalf of Ms. Lakela Kwanda, the former PA to the former president. She's been implicated in the Mentor matter. And although we've received short notice, we also do not intend to uphold any of the proceedings, and we are considering a position in terms of Rule 3.4. Thank you, Chair.
Thank you very much. I don't suspect that, Mr. Maleka, you have anything to say in response to what the various council have said. Basically, in terms of what should happen from now on in regard to them.
No, Chair, I don't have much to say except to ask you to note the following. That as far as we understand the rules and the regulations, no person has a right to cross-examination. And that whoever wants to cross-examine a witness who gives oral testimony before you, they must make an application to you. One requirement of that application is that they must file with the Secretary of the Commission a sworn statement indicating the extent to which they dispute the written testimony of the witness concerned. To the extent that it is now common cause as between us and our learned friends who represents the implicated persons now on record, they have now made an application that they would like to cross-examine those witnesses. And we're grateful to them that they're not going to interrupt the oral presentation.
Well, I don't think anybody has made the application as yet, but I have no doubt that they, or at least some of them, may be intending to do so in due course. What I understand to be the position is that they are saying, in terms of the rules, once their clients have received a witness statement that's alleged to implicate their clients, they have a certain period within which they must respond to that statement. And at least I think most of them are saying they received the notices. The notices they received didn't give them enough time to deal with that, because that's the first step after receiving the notice of witness statement which implicates your client. And I think what they are saying in effect is we need to consult and be able to respond to these allegations. We are not asking that proceedings be adjourned until we have done that. We think that it will suffice if the witnesses implicating our clients continue to give evidence, as long as we will be given an opportunity to read the transcript and then have an opportunity to cross-examine. Obviously, they will have to apply for leave to cross-examine, and technically they would only know whether they want, or their clients want to cross-examine once they have dealt with the issues that are on which their clients are implicated in the affidavit. So my understanding is they are not making the application now, but I think we can expect that they may well make that application after they have dealt with the first hurdle, namely a response to the witness statements that their clients have received.
I understand, Chair, so I would not raise that issue any further for the present purposes. All I wanted to put on record is that we have returns of services indicating when the statements were served on the implicated persons. I'm not going to raise the debate at the moment. It might become important, but just to indicate to you that the first set of notices were served on implicated persons, including Mr. A.J. Gupta, on the 1st of August this year, the 6th of August this year. And we may have a debate in due course about whether or not that is reasonable within the meaning of the rules. So I leave that issue for later debate.
As I indicated, I would be inclined to give persons who are legal representatives who need time to comply with the rules in terms of responding to statements that implicate their clients, particularly when we are able to proceed while they do that. They have asked to be given a chance to consult with the Commission's legal team to see what may be agreed, which will be subject to my approval in terms of what time they should finish those responses. I think that the best way to deal with this is that since it's now 1:45, we should adjourn now for lunch earlier than would normally be the case, and the time can be used to discuss, for discussion between the, or part of the time can be used for a discussion between the legal representatives of the various parties with the Commission's legal team. And when we resume after lunch, then I can be informed of how far those discussions went. So I think that's what we are going to do. We would, I would say we need to come back at 2, but I don't know whether the 15 minutes before lunch, which we have now, and the lunch hour, or part of it, you counsel too must eat during lunch, whether that would be enough for the discussions or whether we should start a little later than 2 o'clock. I don't know whether anybody is able to indicate whether 2 o'clock will give you enough time.
Chair, can I suggest that we resume at 2 unless we inform you otherwise?
Very well. We will then adjourn until 2 o'clock.